Hello there.
Hi.
Mine's sitting next to my friend as usual.
Always enjoy it. It makes me tame my mouth, so that's always a good thing.
You know, maybe it makes me tame my mouth. That would
Yeah.
be nice if it was true.
It's good for me to be mindful, so.
He told me to, I said, yeah, prepared.
Yes, he was.
Oh, he put him, I didn't put mine on.
He was like, oh, I got he didn't realize when he put him on the
Did y'all's jury come to a?
We didn't do the deliberation for hours because March is like the last.
I know everyone wanted to get out.
Yeah, we wanted to get out.
Yeah. Yeah, because y'all are coming in after me. I cannot imagine.
Sorry.
There's like no
But it was such a good, how was, you had yours too?
I thought
That was on
about it.
Tuesday.
How was it?
It was good. Everything was fine, but making objections, like I'm in Florida evidence is still hard.
Everyone had.
Yeah. I was trying to impeach and they objected to it, and I was like, Your Honor, may I respond? She's like, no, whatever you're doing is wrong. I'm like, okay.
I tried to lay a foundation to get something to be able to say.
Yeah.
I did it literally out the book.
I did word for word off of a whole YouTube thing I watched, and she was like, you're doing it
I
wrong.
watched it too.
Oh,
My opening.
sometimes you have to, especially for rules. It's hard to like. The rules don't say what you have to do. So, like impeachment, it doesn't say you have to credit, confront, all that stuff. Yeah. Yeah. Mm-hmm.
And she sustained it, like, it didn't even work.
I know. Well, I objected to her saying she overruled it, and then the next sentence,
I didn't know that was one or two.
she's like, you should have objected to that. I'm like, I didn't know overruled me. It was fun though. She was cool.
Yeah.
She would like lay it into us. She's like, I want to end on a positive note. She's like, everyone did great. Like you know, good damn well you did not think we all did great.
It was good. It was actually a good experience.
Oh yeah, it was fun.
Oh my god.
This class started at 5:45 or 6. I know. Usually my whole row's here and no one's here. Yeah. It's nice not to have class tomorrow though.
Yeah, I was just like, and then after I went
Yeah. I think he
No, you open the door. Sit down,
Hello. I was here, no one was in here. And I was like, am I missing something? I'm glad it's not. I'm right here. I just water all over here. Of course you did. I don't know. It's not like I know. That's why I ran into Julia. Did I miss something? What? Well, once you both texted you, because I'm about to get back to all the cafe. Yesterday I saw her walking. But I missed Julia. Oh, I know. I started watching and I was like, I woke up and I was like, she's like, look at me. I mean, I'm online dating. I'm like a teen again. It was so funny. Is she coming? Oh, she wasn't in the cafe?
No, she
She probably stopped. Yeah.
Oh, I know I will.
Yeah. No.
I mean, it doesn't say like dairy or anything, but yeah. No, because like I
Such a good
Are you
signed up for.
I mean, it's so cool.
Did you write today's date on you?
which section? Trilog? Good. It'll be fun.
Welcome back, everybody.
I was
Welcome back.
Splendid today.
And we're getting down to the home stretch. We're almost done. So we've got today's class, just 2 more hours of me today. And then we've got our next class, just 2 more hours of me there. And then you can forget you ever met me.
Not
You
next
never
week.
have to listen to me run my mouth again if you'd like.
Oh, no, we're doing this here.
Oh, thank you. Thank you. I gotta be honest, I'm gonna miss y'all too. It's been a great class for me, and I've really enjoyed it. I've seen so much participation, and I always appreciate that. You remember from the syllabus, and I certainly enforced it in the beginning. I had my lead counsel sign up. And one of the reasons I do that, one of the many reasons, is to kind of compel individuals to participate in class. But it quickly became evident that I didn't need to compel y'all to do that. So many of you have spoken up, so many of you have participated. And you know, I don't criticize those who prefer not to speak up. I don't criticize those who prefer not to participate. Because stop me if I told you a story already. I was one of those individuals in law school. Have I told the story already? Stop me if I have.
Tell
Well,
again.
all through my bachelor's degree, I never once spoke in class, and I always sat the furthest I could from the front of the room. That was just my style. I didn't want anyone to see that I was there. I didn't want to answer questions from a professor. I didn't want to participate. And when I got to law school, I thought, well, I need to change my ways. You know, I need to participate. So there it was. It might have been my first class in law school ever. It was certainly my first class in torts. Everybody remember their first class in torts? Now, I don't know about you. I didn't have a lawyer in the family. I didn't have a lawyer who was a friend. I didn't know what it was like to be a lawyer. I didn't know what it was like to go to law school. Maybe some of you read Scott Turo's 1L. Still to this day, I've never read it. Maybe some of you have read The Paper Chase or at least saw the movie. To this day, I've never read The Paper Chase, and I've seen a couple of clips, but I've never seen the entire movie. So I didn't know what to expect. I was going into law school blind. I didn't know what a tort was. But there I was in tort class, and I realized what a tort was, and it was I don't know if you still cover this class, it was the flaming bunghole case, if you remember that one. With the gas can that blows up. No, you don't remember that. Yeah, and part of the case was that they failed to state a cause of action. So I rose my hand. I was committed to participating in class from now on. I'd never done this before. So I asked, if the lawyer hadn't even stated a cause of action, wouldn't the lawyer be guilty of malpractice? I didn't know this was an irrelevant question to the discussion. And my professor, Charles W. Earhart, the one and only Charles W. Earhart, former federal prosecutor, current author of the book, which back then was called Florida Evidence and now is called Earhart's Florida Evidence, because the name Earhart sells a book. Believe you me, it sells a book. The man participated in writing the Florida Evidence Code, and ever since then, courts have been citing his book for what his code means. And here I am in his class. I couldn't possibly be more intimidated in my life. And I had finally gotten the nerve to raise my hand, and I made a comment, and he just stops. And I'm toward the back, and he walks all the way toward the back. And I'm sitting down kind of low. I'm 5'4", as you've noticed. And he's, 6 feet, 7 feet, 9 feet tall. Very intimidating character. He's got that beautiful southern drawl. He leans over inches from my face and with his booming voice says, "I don't know, would it?" And that was the last time I ever spoke in law school. I never once, again, rose my hand or voluntarily participated in law school. So I have no criticism for those of you who prefer not to participate, none at all. But at the same time, I'm thankful that this group has been great at participating, insightful questions, beautifully phrased questions, wonderful commentary. I've really enjoyed the class, is my point. So I'm thankful to all of you. My prayer today is a prayer of thanks. It's thankful for you. And before I get to the prayer, last thing I want to do is silence your discussions. Clearly, participate all through today's lecture. But our next lecture will be divided in half. Part of it, the smaller part of it, will be new material. The other part of it, the larger part of it, will be a review of our class. And the review of our entire semester is that by its very nature. It's a review. By the very nature of a review means it is not all-inclusive. No review can be all-inclusive. Otherwise, it would be not a review, it would be a repeat, right? And I can't give you another 26 hours of me running the mouth. I can only give you a review. So please don't substitute the review for reading. Don't substitute the review for studying. Likewise, if it's on the review, that is not your assurance that it is on the exam. On the flip side, if it is absent from the review, that is not your assurance that it's absent from the exam. I just want to make a nice, coherent review. So I may have included some things you won't see on the exam. I may have excluded some things you do see on the exam. There's got to be a reward for coming to classes that weren't the review. There's got to be a reward for having read the textbook in addition to coming to the classes. So the review, by its very nature, is not all-inclusive. And the reason I bring it up in the context of participation is because the review is me covering a lot of material in a short amount of time. And because the review has a point to make, when I start the review, I will respectfully ask that it be purely a lecture and that we don't have questions from the floor or comments from the floor at that time. And I'm sorry to point that out because I really love that part of our class the most. But if I'm going to make the best use of the time and give you a thorough review, I got to stay on script, so to speak. So this class, keep on participating. I love hearing you. Next class, for the new material, for the beginning of it, keep on participating. I love to hear from you. And then I'll let you know that it's the review. And at that point, I'm going to go into robot mode. I might as well have recorded the review, which is hit play. So, and that works best, I've found. I found that works best. So any questions about where we go from here in our final two classes? All right, with that said, back to my original point. I have an attitude of gratitude, at least that's my goal, because I need an attitude of gratitude because I am grateful for you. So my prayer goes out to you. Oh, and as always, thanks for putting up with me as I start every class with a prayer. It's my understanding not every professor does that. All right. In the name of the Father, Son, and Holy Spirit, amen. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done, on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. Hail Mary, full of grace, the Lord is with thee. Blessed art thou among women, and blessed is the fruit of thy womb, Jesus. Holy Mary, Mother of God, pray for us sinners, now and at the hour of our death. Amen. Remember, O most gracious Virgin Mary, that never was it known that anyone who fled to your protection, implored your help, or sought your intercession was left unaided. Inspired by this confidence, I fly unto thee, O Virgin of Virgins, my mother. To thee do I come, before thee I stand, sinful and sorrowful. O Mother of the Word incarnate, despise not my petitions, but in thy mercy hear and answer me. Lord Jesus, thank you. Thank you for this great semester, for this great group. I hope I didn't annoy them too much. And if it's your will, let me serve them well now and in the future. Amen. In Father, Son, Holy Spirit, amen. Okay, so where did we leave off? We left off at subsection D of our chapter regarding privacy, and we left off at City of North Miami versus Kurtz. And one thing we've got to make sure to do is pass that attendance sheet around. Did you? Oh, it's already going around?
Yeah.
Okay, all right. All right. I like to do that after the prayer. If anybody came in after the prayer, please make sure they get a chance to sign in. So if you're here, sign in. It's good advice, right? If you're here, sign in. Thought so. Anyway, I left you with a question about City of North Miami versus Kurtz.
It's not on.
I don't think it was on. It's good
Oh, well.
effort, though.
Well, you know,
Is it dead?
I don't know. I really don't know. Yeah,
Did you turn it on?
I did. It's got a little light on it. Yeah,
It's probably.
it's got a number. Oh, and it has a drawing of a battery that's empty. That could be the problem. All right.
I would guess
But you know
that.
what's not empty is our slide here because it's got City of Ed, Miami versus Kurtz on it. Like that segue. Smooth, right?
That was good.
So I left you with the question about City of North Miami versus Kurtz. And that question was, what was the court's analysis? Did it first turn to the federal constitution and the federal right to privacy and then turn to Florida's constitution and the Florida right to privacy? Or instead, did it turn first to the Florida constitution? Who can answer that question for me? Oh, I didn't discourage y'all by saying you can't speak next week. I should have just mentioned that next week instead of this week. All right. But I think you can see here that the Florida Constitution was its first analysis. And then after that, it turned to the federal Constitution. So this could be guidance for the future as to how to analyze privacy claims when it comes to a Floridian who is asserting a right to privacy both from the text of Florida's Constitution and from those penumbras formed by emanations of the federal Constitution. The prior point here, how do we determine whether an expectation of privacy is enforceable or a legitimate expectation? And as we mentioned very briefly on the way out the door last week, what we're looking for are objective manifestations. Objective manifestations. So if Florida's right to privacy is different than the federal right to privacy, and again, I'm here to put forth hypotheses, I'm here to teach, not to indoctrinate. So feel free to disagree with any of my hypotheses. The purpose of going to law school is to learn how to make arguments, not just to memorize someone else's arguments. So if indeed Florida's right to privacy is different from the federal right to privacy, perhaps one way it is different is that it is fleshed out when there is a legitimate expectation, or stated somewhat differently, when can I enforce a right to privacy? When do I have a right to privacy? When is there a legitimate expectation of privacy? And under Florida's case law, in interpreting privacy as that right appears in the text of Florida's Constitution, we look for objective manifestations. What is meant by objective manifestations? Well, you remember the facts of City of North Miami versus Kurtz. There, the allegedly objectionable employment law question. Indeed, the employee was asked to sign an affidavit affirming the employee had not smoked tobacco within a certain amount of time in order to even be considered for employment by the City of North Miami. The question there was, do I have a legitimate expectation in whether or not I'm a tobacco smoker? That was the question in City of North Miami versus Kurtz. And what was the court's answer? No, because as you remember, back in the day, whether or not you were a smoker was something that was evident in public. You remember the examples we went over. When you walk into a restaurant, back in the day of City of North Miami versus Kurtz, what would the hostess ask you after? How many people in your party? Smoking or not smoking? When you tried to rent a car back in the day of City of North Miami versus Kurtz, did you want a smoking vehicle or a non-smoking vehicle? When you were renting a hotel room to stay in, did you want a smoking room or a non-smoking room? And of course, back in the day, where did you smoke your tobacco? Yeah, you'd smoke outside. Sometimes you could smoke right there in a public building. Another example I gave last week was if you're in a nightclub or a disco or a dance hall or whatever the kids are calling those things nowadays. I always sound ancient when I use that phrase, don't I? But whatever you might call a place you'd hang out and go dancing, you'd smoke right there, right? Indeed, if you're a non-smoker, you'd still come home smelling like smoke, right? Yeah. So there wasn't objective manifestations of keeping such an activity private. So let's extrapolate. Let's think about that legal standard. Let's try to apply it to some of the unanswered questions of the day, or some questions that might, who knows, might need to be answered in the future. Now, the federal right to privacy, which, as we mentioned, doesn't appear in the federal Constitution. You remember that part of our lecture? But the penumbras and emanations of that federal Constitution have been found to create this right to privacy. Does that right to privacy then yield a right to abortion under federal law? Oh, come on. Surely somebody studied this before. Have I trod into areas we dare not speak? I warned you, day one, hour one, as I began this class, Sister Rosemary Finnegan here is my guest lecturer. I warned you, this is not a class where we avoid the hard topics. I warned you, we talk about things like abortion. We talk about things like youth in Asia, youth in Europe, youth in Africa, youth all over the world. We talk about all these things. So under federal law, there is a federal right to an abortion, correct? Is there such a right under Florida law? Well, of course, because federal law applies to Florida, the answer would be yes. But let's dream up a crazy hypothetical. What if it actually never appeared in the federal Constitution, a right to privacy? What if, hypothetically speaking, you could pull up the text of the federal Constitution on your word processor, hit Apple search or Control F or search in page, and you didn't find the word privacy? What if, this is just hypothetical, some later court found, well, prior precedent was wrong. There's not a federal right to privacy. And of course, I'm speaking in the hypothetical because we don't have any SCOTUS rulings of that nature. If we did, then would there be a right to privacy to have an abortion under Florida's Constitution? What do you think? What's the test? What's the analysis? Well, we need to know whether there's a legitimate expectation, correct? We know that from City of North Miami versus Kurtz. And what does that test mean? How do we know whether there's a legitimate expectation? We look for what? Objective manifestations, right? How do we know whether there are objective manifestations? Well, one example we know from City of North Miami versus Kurtz is what? Okay, but what did smoking tell us about whether there were objective manifestations?
It's not it's not something that society reasonably expects or believes to be private. You're outside smoking a cigarette, whereas with an abortion, it's a medical procedure under, say, HIPAA regulations, for example. That's private information. Society recognizes that as something that shouldn't be disclosed to the general public.
Okay, and that could be the correct answer under this undecided, unknown analysis, right? You seem to be applying the analysis correctly. Can anyone apply the correct analysis and yield a different result or make an argument for a different result? I'll do my best. I'll try. And again, I'm not here to indoctrinate, here to educate, just making an argument. What if City of North Miami versus Kurtz found objective manifestations because this was publicly available information? What if you could readily observe whether a person was a smoker? What if that's the proper interpretation of City of North Miami versus Kurtz? If so, and we take that analysis and we apply it to a pregnancy, if a woman is 8.5 months pregnant, 9 months pregnant, is that visibly evident to others? Can someone look at a woman who's 9 months pregnant and visibly tell? What about 8 months? What about 7? What about 6? What about 5? What about 4, 3, or 2 months? You see how this kind of analysis, if it were the applicable analysis, might yield the same result as we currently have under federal law, or might yield different results. And again, I'm here to educate, not to indoctrinate. With that said, you know what my beliefs are. I'm pro-life, but perhaps you're pro-choice. If you'd like to learn from me how to make the pro-choice argument, I'm sorry to disappoint, but I explained that in class 1, lecture 1, hour 1, pretty close to minute 1, that I wasn't here to do that. My beliefs are my own, and I respect your beliefs, and I welcome a dialogue about those beliefs. But with that said, there appears there could be a difference in the analysis if all that were left of a right to privacy was not the penumbras and emanations from our federal constitution, but instead the texts of our various state constitutions. Is that good or is that bad? Is that right or is that wrong? That's for each of us to decide. For me, I've made that decision. But this is a decision you will have to make. This is a decision society will have to make. And this is the case law. This is the legal rubric. This is the standard by which we currently have courts making that decision. So some takeaways from the City of North Miami versus Kurtz case. First of all, Florida's right to privacy provides greater protection than the federal constitution. How do I know that? Because it says so in the opinion, right? That's why I put quotes around that phrase. Another takeaway, we analyze objective manifestations to determine whether there's a legitimate expectation of privacy under Florida's constitution. So if it's a valid criticism, again, just a hypothesis, I'm here to educate, not to indoctrinate. If it's a valid criticism that under the federal constitution, It means whatever those who happen to be justices sitting at the Supreme Court at that time believe it should mean when it comes to a right to privacy. That need not necessarily be the same outcome of Florida's textual basis of the right to privacy that appears in the text of Florida's Constitution. Because here we have a legal standard promulgated based upon an adequate and independent state law basis, that being the Declaration of Rights, Article 1 in Florida's Constitution states a particular right to privacy, which is later interpreted by our state's high court in decisions such as City of North Miami versus Kurtz. The third takeaway, we need not resort to the federal right to privacy if Florida's greater right to privacy protects the individual. So what we see from City of North Miami versus Kurtz, if a litigant is arguing the right to privacy under both the federal and the state constitution, to which will state of Florida courts turn first to answer that question? The state constitution or the federal? Yes, the state, yes.
I was gonna say same privacy.
Yes. Sorry.
Just privacy approach, yeah.
Yes, a primacy approach. Yeah, absolutely. Absolutely right. So, is Florida's right to privacy truly broader than the federal? I included in your textbook an excerpt from a law review article that appeared in the Florida Law Review. It spoke exactly about that question, and it spoke about City of North Miami versus Kurtz. It also spoke about the case we covered prior to City of North Miami versus Kurtz, Winfield versus Division of Parimutuel. And the Florida Law Review printed this conclusion. After Kurtz, however, it is apparent that the state constitutional right to privacy in Florida extends protection no greater in scope than the minimum federal guarantee. The Florida Supreme Court could not have narrowed any further the scope of the privacy protection extended to Floridians. My question, is this commentator correct? Hot button topic, no one wants it. I believe you could argue the commentator is correct. Florida Law Review must have thought so, they printed it, right? Certainly you could argue that based on the analysis you see in the excerpt from the article that I gave you. Part of that excerpt illustrates how Kurtz lost the case despite the legal standard that arises from the case. Looking at outcomes, as the commentator did, Florida's right to privacy looked no greater to the commentator than what we find under the federal constitution. How could a different commentator, such as you, come to a different conclusion, stated somewhat differently? If you're licensed to practice law in the state of Florida and your client has hired you to make the argument for the different conclusion, how would you make that argument? How would you argue that Florida's right to privacy is greater than what we find under the federal constitution? Well, here's an example. What did we learn from Winfield? Winfield lost also. But what did the opinion in Winfield tell us about the right to financial privacy? That it exists under Florida's constitution. Has there been a ruling for the Supreme Court of the United States that say Americans have a constitutional right to financial privacy? No, not under the penumbras and emanations that the Supreme Court of the United States have found to have created the federal constitutional right to privacy. I'm not saying that there aren't banking laws. I'm not saying that there aren't a code of federal regulations interpreting banking laws. I'm not saying that your bank can certainly go around talking about your bank balance. Obviously, those laws prevent such a thing. But what I'm asking is about a federal constitutional right. Has financial privacy been elevated to the status of a federal constitutional right? The answer is no. Yet here in Florida, as we know from the obiter dicta that we find in Winfield versus Division of Parimutuel Wagering, financial privacy is indeed within the text of Florida's constitution that says a Floridian has a constitutional right to privacy under Florida's Constitution. So in Florida, financial privacy has been elevated to a constitutional right, a state constitutional right. So if we're looking for differences to compare and contrast, there's one. Does that sound like a greater right, the same right, or a lesser right? I think the argument can be made that that's a greater right. That would justify quotes such as this one, to flip back a slide, that we saw in City of North Miami versus Kurt. That would justify conclusions such as Florida's privacy right provides greater protection than the federal Constitution. And that would dispute conclusions such as we see in the Florida Law Review and in this case comment that I quoted from. So does that help you to perhaps flesh out the argument either way? Hope so. Notes and questions to consider. Is there a right to financial privacy under the federal Constitution?
I just have one question.
Sure.
When you said in Florida elevated to state constitutional right, can you just repeat that?
Sure, yeah. My point was this. Certainly, opinions of the Supreme Court of the United States have interpreted the federal Constitution, for better or for worse, to have a right to privacy, even though you can't find the word private or privacy anywhere in the text of the federal Constitution. So what's the scope? What does it protect? What does it not protect? We've got to turn to opinions from SCOTUS, the Supreme Court of the United States. And we don't have an opinion that says there's a right to financial privacy. That doesn't rule out that there might be a statute, Code of Federal Regulations, agency rule, what have you. But elevating it to a federal constitutional right has not happened to this date. Compare that now to Florida's Constitution, and that helps answer this question. I can segue your question right into this one. Is there a right to financial privacy under the federal Constitution? No. Is there such a right under Florida's Constitution? Yes. Where? Article 1, Declaration of Rights, specifically has the word privacy in it. Gives Floridians a right to privacy. It says so right there in the text of Florida's Constitution. We don't need a penumbra. We don't need an emanation. Right there, Control F, Apple F, search the document, the word privacy shows up. What does it cover? What does our state's high court say? Cases such as Winfield versus Division of Parimutuel say that it covers financial privacy. So that's my point. That's the compare and contrast. That's the difference. And in my opinion, that's a way to argue that Florida's right to privacy is greater than the federal right to privacy. Point 2, if the Supreme Court of the United States held there was never a right to privacy under the federal Constitution, then would a right to privacy still exist in Florida? Would it?
Yes, if they're allowed to.
I would agree. Why do we say so?
Because they're allowed to give more rights than what's guaranteed by the protocol. That's just the minimum core.
There you go. Thank you. And that's a wonderful way to put it. And in so doing, Floridians have added and amended our Constitution to put a right to privacy in there. Thank you. Well said. So if SCOTUS holds there was never a right to privacy in the federal Constitution, I would argue, yes, there's still a right to privacy in Florida, but that is not the ultimate question. If SCOTUS said there was never a right to privacy in the federal Constitution and Florida still has a right to privacy, to what extent would your and my and all Floridians' privacy right be different today than it was before SCOTUS made such a hold? Who knows, maybe someday we'll live in such a world where that question is answered definitively. But at this point, we don't know, do we? We can conjecture, we can guess. If we were to make the argument, what would we turn to? Excellent choice. Then you would find an adequate and independent state basis in the text of our state constitution. Then you would have case law precedent from the Supreme Court of Florida that was interpreting not the federal right to privacy, but the state right to privacy. Remember from City of North Miami versus Kurtz, a primacy approach would be the proper approach for courts to take. So hopefully you would have a body of case law precedent that was interpreting a constitution, the state constitution, that had a right to privacy and that was still good law because it didn't rise or fall based upon the rulings of SCOTUS, right? This is making sense. Do you see how these two rights can be separate and distinct despite having the same name and in many cases protecting the same interest? Okay. So let's turn to subsection E. And here we talk about Florida's right to privacy and sexting. Yes, that's right. If abortion wasn't controversial enough, now let's turn to sexting, shall we? What is sexting? Sexting is a portmanteau, right? It is a combination of the word sex and texting. For those of you who didn't know, my mind's not in the gutter. My mind is on the First Amendment Law Review. That's where I get the definition of sexting from. So sex and texting, this is an activity involving sending nude, semi-nude, or sexually explicit depictions in electronic messages. God bless you. Most commonly through cellular phones. For those of you who didn't know, I'm just like you. I had no idea. Good thing we all read the First Amendment Law Review because now we know. What about sexting? Is Florida's right to privacy protect sexting? The even more difficult question that I tried to raise by turning to the First District Court of Appeals decision in AH versus State of Florida. What does AH stand for? It stands for a first name and a last name that we do not know, because when it comes to the rules of appellate procedure and the relevant Florida statutes, when the party is a minor, we protect the party's privacy. We don't put the party's full name. We just put the party's initials. So we speak now of a minor, AH versus State of Florida. A quote here from somebody named Joseph Abruzzo. Don't know who he is. Honestly, don't know where Wellington is either. But I like the quote. We shouldn't be labeling our children sexual predators from this type of behavior. Stole the quote from this guy, Lawrence Walters, who had the quote in How to Fix the Sexting Problem. Again, in the First Amendment Law Review, because that's the only way any of us have ever heard of the word sexting, right? That's our story. We're sticking with that.
Yes.
Okay, I'll see a lot of agreement on that one. Okay. So should we be labeling our children sexual predators from this type of behavior? What happened? What were the facts of AH versus State? Who wants to share those with me? Yes. Thank you. Tell us about the facts of AH versus State.
Okay, well, it's a time frame, and then there's the 16-year-old and then 17-year-old, and they're having to go with themselves, engaging in situations.
They were.
And the state alleged that while the photos were never shown to the third party, AH and JGW emailed the photos to another computer from AH's home.
Yeah.
And so they were charged with one count of producing, directing, and promoting a photograph or representing that they used to include the sexual conduct.
So charged with a short litany of crimes, despite being 16 and 17. Is that right? Yeah. But what was the outcome? Was there a conviction? There was. And there was an appeal. And what about the right to privacy? By way of background, Florida case law holds that sex is covered by that legitimate expectation of privacy. By way of background, Florida case law holds that sex between consenting minors is protected by the right to privacy. But yet here, we have a conviction involving child pornography because a boyfriend and a girlfriend, both minors, both under the age of 18, one 16 and one 17, the facts tell us these minors were not pornographers. They were not making videos for profit. They were not distributing the videos to others. This wasn't an example of sexploitation. This wasn't an example of one exploiting the other, trying to sell the profits or blackmail the other for the sexting. The facts tell us we had two kids in love. who shared sexting pictures. And now there's been a conviction. Who here is familiar with Florida criminal law when it comes to a conviction for sexual misbehavior? What happens to he or she who is convicted of such a thing in Florida? Yes.
Are you referring to having to register as a sex offender?
Yeah. Register as a sex offender. So here we have two kids fell in love. They engaged in something called sexting. And now one of them is labeled and registered as a sex offender for the rest of that minor's life. What about the right to privacy? Why didn't? Oh, and well done, by the way. Thank you for covering the case. Hard one to talk about, right? But you did it well and professionally, and I appreciate that. So, no, I do. I appreciate that. Thank you. So, Judge Wolf wrote for the majority. Here we had a 3-judge panel. That's how our DCAs rule. Judge Padovano had a dissenting opinion. We can compare the two. Is Judge Padovano's opinion the law of the land? No, it's a dissenting opinion. The majority opinion written by Judge Wolf, that is the law. But let's compare the two so we can criticize or praise the law as it turned out. Judge Wolf, for the majority, found that the prosecution of minors was the least intrusive means of advancing a compelling state interest in eliminating child pornography. And on that point, I'm sure we have much agreement. Pornography in general is a plague upon our society, but child pornography is a plague that we all must be committed to wiping out. We simply can't have child pornography in a civilized society. We can't have individuals spreading child pornography. We can't have individuals possessing child pornography. Judge Padovano recognized that the government has an interest in both limiting and eliminating child pornography. Judge Wolf, writing for the majority, said that that government interest rises to and satisfies the test of being the least intrusive means of advancing a compelling state interest. So with that said then, and in what I hope is dicta, the majority's opinion written by Judge Wolf tries, and I guess succeeds because it is the law of the land, but if you wish to criticize it, tries to give examples of how the child's behavior lacked objective manifestations of legitimate expectation of privacy. And the opinion wasn't written yesterday, but it wasn't written in ancient times either. Yet sometimes the words we see there, I'll paraphrase them here, almost sound like ancient days. They almost sound like an ancient civilization trying to describe modern America, don't they? The majority opinion describes how there's something called them internets. Again, I paraphrase. But apparently them internets mean that something called a computer is linked to other things called a computer. Again, I paraphrase. And that's something called the email. A lot like mail, but with an E out front. The email. When it goes from one computer to computer, stops in various things along the way called servers. So these internets made up of the computers sharing the emails among one another is leaving copies of the emails all over the servers, which aren't owned by either the sender of the email or the recipient of the email. And therefore, there's no legitimate expectation of privacy because the sender of the email is just scattering the emails all over the servers and all over the computers through something called the internets, which, the majority points out, can be hacked. Oh, my Lord. You're raising your hand. You're right. I didn't exactly quote verbatim from the opinion, did I? Yes, I seem to forget something. Go on. The hacking.
Yeah.
Yes.
They have a duty to prevent children from doing these types of things and that, they're not old enough to understand, to make these types of actions, or what did it say? That they're not responsible enough.
That's an important point.
Type of act.
Yeah. And by pointing out that minors are not responsible enough to do these kinds of acts, the majority opinion, I would argue, is consistent with other areas of the law, where we protect those who are in a legal age of minority, or perhaps the opposite might be under a disability such as old age, where we try to protect such individuals from themselves, right? Where they may not understand the full repercussions of their own behavior. Look, for example, at guardianship law, where we appoint a court-appointed guardian to make financial and even marriage decisions, social decisions on behalf of a free individual because that individual warrants such protection. Same thing happens with children, right? So the majority opinion, if we put my critique of technology aside, is consistent with other areas of the law. Your hand is up, yes.
But if you take that view of the law is supposed to protect these children, and that the best way of doing that is to prosecute them criminally, then you are automatically making the assumption you're blocking off any possibility of explaining to the child and educating them on why their behavior is bad. You're just saying it is bad and you'll be punished for it.
Yeah.
You're not teaching the child how to avoid it. What if they grow up one day to be an adult? At 18, you don't magically get all this knowledge of being an adult. You don't automatically become better at doing what you weren't taught. So by punishing them criminally, all you're doing is teaching them that the system is designed to screw them.
Yeah. And I hear your point. I don't disagree with it. To summarize it, if I'm summarizing well, as perhaps the criminal prosecution is insufficient to deter future behavior.
Yeah.
And perhaps
blocking not letting kids send photographs of themselves naked to each other is totally fine. Absolutely agree with that point of it. But prosecuting criminally is the absolute wrong way of dealing with it.
So stop the child pornography, stop its transmission, but maybe prosecuting the child, making a minor on the list of sexual predators for the rest of their life might not be the right answer. I hear what you're saying. Agree, disagree? I don't know which hand was up first. Maybe yours.
Okay.
Yours?
I think he was before.
Yours was up first.
Well, I just 2 points just to jump on the back of that. I think I understand we're looking at deterrence policy where we want to root this out.
Yeah, we do.
But I feel like the nature of the 16 and 17-year-olds,
Mhm.
we should be focused on rehabilitation as opposed to blacklisting.
I don't see a focus on rehabilitation.
Right. It's we're looking at that policy. And
I think your
it's-
point's well taken.
Right. So, and then my other thing would be the nature of pornography, and I don't have another definition in front of me, but in theory, it's to disseminate, to spread to people, to buy and sell and to distribute. And I think that needs to be kind of like a criminal intent thing. Did you mean to send this to people? Or did it accidentally get to
Well,
people?
you raise a
And
good
that's-
point because the law of the state of Florida, much like the law of many states, doesn't require criminal intent when it comes to possession of child pornography. You either possessed it or you didn't.
Right.
It's not an absolute defense to say, oops.
Right. I just
So
feel
you
like
raise
we
another
have
good
some
point.
caveat for it being their bodies and not the bodies of their peers or something like that, where it would be they're spreading this and the
So
process
you would
is-
carve out that kind of exception.
those seem like reasonable distinctions
Okay.
because it doesn't seem like these are the kind of people that this blanket statement is trying to stop.
Well, and that may be another way of rephrasing whoever that state representative was, that person's point. Yeah. No, I see what you're saying. You were next.
Yeah, I was so under, states do have an interest to prevent statutory rape.
Yeah.
And because they
Well,
recognize-
statutory rape is an excellent thing to point out here because,
So
another example of protecting minors from themselves. I like that point.
Yeah, so, and because they recognize that a lot of kids start having sex at very early, 14, 15 with each other, they have this Romeo and Juliet laws that if you're within a certain age gap with each other, and I think Florida has that too, that you can't be prosecuted for statutory rape. So is there anything like that for this one that if you have
Not that I know of.
16, 17 and are children? Because kids do this,
Yeah, they do. And no, not that I know of. I checked to make sure age is still good law, and it is. And I'm unaware of any statute like you're talking about when it comes to child sexting. Whose hand was next? Was it yours?
I was just saying that the court was kind of, talking a lot about the fact that there's 117 photos. It wasn't just one photo.
Yeah. How does that factor into analysis such as yours? We're not talking about one odd photo. 117 was the number? 117. Yeah.
No, I'm just saying, like, it's easier for one of 117 to accidentally get out and like sold rather than just one picture.
That's true. And once it's out, once it's beyond these two parties, and it becomes something that can be sold, the majority opinion talks about, God forbid, but it's true, a street value
Market value.
for child pornography, a market value. Yeah, and we've got to make sure there's no child pornography and certainly no market for it.
Right. I think there's an example.
And so you see a potential for a deterrent effect.
I do. I mean, if I knew about this case, I would never said, I never said anything, but.
No one's accusing you.
She said, if I knew that, I would never.
No. I was hoping to have like. Yeah.
Yeah. Whose hand was next? Was it yours?
Yeah, so I agree with both of them, and I wanted to say similar things, but to further build off of what they're saying, is that about carving out exceptions. You know, we're in the golden age of technology. Things were not, and I'm not even old, I'm only 29.
Me either. I'm not old. Who's laughing?
When I was a teenager, you know, if social media, pictures, and you know, everybody having phones and all this access to technology, it wasn't that way even, you know, when I was 14, 15.
Yeah.
So I do think there needs to be rehabilitation, this needs to become part of the curriculum, and not because, oh, people don't have enough, you know, common sense to figure it out themselves, but no, it's a prevalent thing, so, you know, people need to be put on notice, and certain things need to be taught, because
Yeah.
you know why it's wrong and why you shouldn't do it.
So you see education as important.
Yes, and child pornography is bad, right, I'm not saying it's good,
Yeah.
but I do think they're keeping this specific little niche, talking about child and child, minor and minor, under 18, there needs to be some type of, distinction of it being a personal exchange. I mean, you literally ruined this person's, not you, but, you know, this person's life.
Yeah.
was
Yeah. Yeah.
over this, and
Yeah.
I there's no justification. Prosecute, go after the people who have the child pornography, who have intent, you know, to do bad things with it, you know, who are pedophiles, not the boyfriend or girlfriend, you know. It's just, it's too
Yeah.
messy, and it's just not okay, and I don't see any justification for.
So are you referring then to prosecutorial discretion? By which I mean, and here in the state of Florida state prosecutors, same as federal prosecutors, have discretion as to whether or not to bring charges. A prosecutor in the prosecutor's discretion can think, well, I could win this case, but I'm not going to bring it. Likewise, prosecutor could think, I may not win this case, but it's important and it's appropriate for me to bring it. So are you saying that there was a lack of prosecutorial discretion here?
There's just so many things missing, you know, these types of cases like this exact scenario, 16, 17, these are the types of cases that need their own statutes with, you know, case-by-case discretion, distinction, you know, all the circumstances and details matter. You know, who was it? Was it forced? You know, what did you do with the transmission? Did you share it with your friend? You know, because it's only between you guys, regardless of whether it's email, hacking, whatever. If your intent is between you two, you're not sending it to your friends, you're not, you know, it's just no. There needs to be more scrutinization there as to the totality of the circumstances of the entirety of the situation, and regardless of whether it's one picture or 117 pictures, you know, there's a chance that these 117 pictures will never get out anywhere. There's a chance that nobody would be none the wiser. So why are you going to label somebody a sex offender at 16 or 17 years old for the rest of their life because they didn't know better? They were just too stupid and young and their hormones are flying all over the place.
Yeah.
That's
You
just not
you
okay.
raise good points, but most importantly, you state them eloquently and you state them by using the appropriate legal standards here. So you're doing a great job. Doing a great job. There's at least 3 hands up. I think yours was first.
Well, I was going to just say that this entire matter is you were talking about education. It's a matter of education. The sad fact is that just say no and abstinence only don't work. The more you tell someone you can't do this, you shouldn't do it, it's wrong, it's wrong, it's wrong, a kid wants to do that. They want to push boundaries. They want to try something new. They want to be edgy or off the rails in some kind of way. So explain, all this does is back to what I was saying earlier, is teach someone that their behavior is bad and not why it's bad. If you don't teach the why, if you don't say, hey, this is bad because someone could take it and sell it, someone could use this in your future against you, you just say, no, bad. We're not going to do that anymore.
Yeah.
Yeah, again, it comes back to the fact that we're trying to protect children from the world instead of teaching them how to live in it.
I see your
We
point.
live in this world. One day.
So,
you wake
and
up
I
and
hear
you're
you
an
going
adult.
back to education.
Yes, absolutely. It's
Education.
the most important thing. And not what, the why. The why is what's important. The
I'm
what
coming back to you, but your hand was up first.
My issue with this case hinges on society has a reasonable expectation of privacy.
Yeah.
Well, I disagree that the child or the teenager should be labeled as a sex offender for the rest of his life.
And that's
I do-
hard. That's a hard outcome to live with.
It is, but I do see him incurring some liability, granted maybe not that strong. Because the reality is, society only recognizes a reasonable expectation of privacy, not just total. Under the Fourth Amendment, if you go to a bathroom stall in an airport and a cop, looks through the thing, just glances, that's reduced, not total privacy. I think the same analogy can be drawn with email servers or anything like that. You send something out, there is a reasonable, knowledge, even if you're 17, 18-year-old, hey, he's going to be somewhere else, someone else.
Well, let me ask you a follow-up question on that point. How do I run modern society if the use of the internet, if the fact that data can be hacked means that I don't have a legitimate expectation of privacy? What bank runs its bank without computers and without internet access? What business keeps its records solely on paper and not computerized? Which one of you doesn't get a technology device involved, whether it's a cell phone or a laptop? I see MacBooks, I see PCs. Anybody got a Chromebook? That's my choice. Nobody's got a Chromebook except me. How about this?
I would,
At home, if I have a question, I say, hey, Google, what's the weather? And my smart speaker there, my Google Home, whatever they call that little dot thing I've got there on the fireplace, tells me what the weather is. And then when I'm making Patrick James and Madeline Marie some nice little hot cinnamon buns that they like in the morning on cold days, I say, Alexa, set a buns timer for 9 minutes. And they always laugh out loud. Buns timer is done. Buns timer is done. And they find that to be hilarious. Does that mean I don't have a legitimate expectation of privacy and what goes on in my own home? Because under Judge Wolf, speaking for the majority, that's connected to the internet, right? That can be hacked, can it not? When I got my new Alexa Echo Show with the screen, I don't want to throw away the old Alexa without the screen. So you know where I put that? On the bedstand in my wife and my bedroom. It's a few inches from our marital bed. Does that mean Bernadette and I don't have a legitimate expectation of privacy regarding the activities in our marital bed?
I'm glad you brought that up because
Listen to everything.
I'm glad you brought that up because that goes back to my point about a reduced expectation of privacy versus a total expectation of privacy. When you go to an airport bathroom to use the stall for your own purposes, people can still see it's reduced. You're not giving up all your privacy.
So have I reduced my expectation of privacy
Absolutely.
in holy matrimony?
No.
In my marital bed? I'm picking you. I'm picking you. You've got 2 hands up. You'd have 3 up if you had a third one. Go ahead.
Break it down real simple.
Break it down.
I like to point out how at least once a year, okay, I have to get a new debit card and file a whatever.
Those
little-
affidavit things.
No, like I have to go through a claim to get my money back.
Or fraud.
Because, yeah, a fraud claim,
Oh.
to get the $86 or the 200 and something that somebody in enough, across the United States. But I do have a legitimate expectation of privacy in my financials. We discussed it.
Thank you.
So if that's.
And
the
I
case,
agree with that
but
analysis.
People hack all the time, and it's just something we have to deal with. That's why I say, go after the people with the malicious intent, the people
Right.
that are hacking, the nasty people that want naked pictures of children.
Go after
the
them.
Screwed up people, go after them.
But to grab a point you made about 2 sentences ago,
Just like
that
go
was a
after the
lot
hackers
like
on the
Judge
dark
Panavano's
web.
dissent.
Okay.
What you argued really was.
It's the same thing.
It much is, because Judge Padovano's dissent takes issue with more than just whether this was the least intrusive means. It also challenges whether the majority's examples do indeed evidence a lack of legitimate expectation of privacy. Just the use of a computer that's connected to the internet, sends things via email, and might be hacked, as Judge Padovano put it. A person's purse might be stolen. Does that mean there's not a legitimate expectation of privacy of what's in a purse? A person's house might be burglarized. Does that mean there's not a legitimate expectation of privacy of what happens in a house? A person's bank account might be robbed. Does that mean there's not a legitimate expectation of privacy in the bank account? You were first.
Yeah, so there are a couple different things, but I think, first of all, acknowledging the bad guys that we're going for, the policies that we're trying to set to keep these people away. And then we have these two kids who aren't in that category of bad guys, right? They're sending pictures of themselves to each other. And yes, we acknowledge that this technology changes the game a little bit, but I don't think that as a public policy we should be fearful of this technology or submitting to the demands of terrorists by the people who can hack this stuff. We shouldn't be living in that fear, because we're all in the same boat. And then I would also say there's an element of the whole Instagram culture where so many people are Instagram models and stuff like that. We have people whose job, and I'm not kidding, I mean, some of us don't, but it's their job to look good and take pictures of themselves in bikinis, and not only bikinis, but it gets more and more and more, it pushes the envelope more and more and more. So it's pretty much this. And then we have these kids who see that and want to emulate that, and their social life is based on how well they can emulate that.
Wow.
And so we're talking one standard deviation from what is not only expected but looked up to, and then now that person's being blacklisted. To me, like a reasonable person should be able to be like, whoa, that's not the person we're going after. We should be helping that person realize that they crossed the line.
Yeah.
And how dangerous it could be.
And you don't see a clear enough line, is what you're saying.
The second we have people sending each other and you're posting to strangers yourself in a bathing suit. And then one standard deviation is a small amount of cloth on, and then all of a sudden that's pornography, and then all of a sudden from 17 to 18 that's a child versus an adult. And for some people that's not a difference. For some people it's a huge difference, right?
Yeah.
But statutorily we look at it and then that's blacklisted, and I think that's asinine, right? It's very different from the person sitting in a closet who has pictures of strange children and they're collecting these photos. That's a different person, and I don't think rehabilitation should be in the cards for that person. But for these kids, it's a different story.
Yeah. And is that your point too?
No, I wanted to conclude my point from earlier.
Oh, sorry, did I cut you off? It was not my goal. Sorry about that. No, go right ahead.
The point I was trying to make, the ultimate touchstone, if you have a microphone in your home constantly recording, and there's an AI or something that has the capability of retaining that information, another company who has dominion and control of that information, you have limited some expectation of that information being yours, because it could inadvertently get hacked by someone else, or the company could use it. I mean, I'm not saying it will, but if they did. So with that being said, sending an email isn't a 100% expectation of privacy. It's being stored on a public third-party server. Therefore, while I don't agree that the fact this kid was, punished to the degree he was, there is some liability, because again, there is a reasonable expectation that another person can access this information.
That argument can make for literally anything. Someone could break into your house and break into your safe.
But the difference is, I'm not inviting people into my house to break in.
I'm not inviting people into my house. I'm not inviting people to look into my email. I'm not inviting people to look into my mail by sending the mail.
But when you send something, you no longer in your dominion or control.
You're right. But it's out of my dominion and control if I'm out of my house as well. Someone could break into my house while I'm not there. It's out of my dominion and control. Yes, it's my house, but there's no. But by saying there's no expectation of privacy, just because. By saying there's no expectation of privacy, just because it goes into a public forum or held by someone else, just because that possibility exists that someone can misuse it, does not mean there's a diminished expectation of privacy to use it.
And I still say it's reduced, not completely gone. It's a reduced expectation of privacy.
I don't see that as a point worth splitting, because either if there's an expectation of privacy, well, it's slightly reduced here, it's slightly more here, slightly more here. If there's if I'm supposed to have my expectation of privacy in this, if I send this envelope to you for you, meant to see you, someone else intercepts it, that person is a bad actor. That's the simple fact of the matter, is you need to punish the person who has the malintent, not the person who just accidentally gets caught up because the text of the law says a certain word.
You see an analogy there.
Yeah, that's a little bit. It's like when you receive a credit card, like the bank didn't send Romeo something with my name on it, you know? But, so why would he exploit that, you know?
Yeah, I see. Yes,
I just have a question. So there's a federal rule against opening people's mail, right? Like,
Yeah.
Is that a private email? Because essentially that's what it is.
huh. You know, I don't know that federal mail statute well enough to know whether it applies to email. Yeah, anybody know?
I don't think so.
Where's our federal mail statute experts?
There is a law.
You're raising your hand as a federal mail statute expert? No.
I think I have a sense on this, you know how we talked about different acts requiring steps and for preparation and to take someone's mail and to open up that envelope, there's no accidental, that has to be multiple steps, multiple actions.
Okay.
To be delivered. It's possible that I thought it was for me, that happens sometimes, but then usually you find it, put it back and you find
Right.
it to the right person.
So you're talking about
Whereas
an
an
intent
email-
statute.
Right, whereas
Right.
an email, it could literally just be a click on accident.
Yeah,
I've had my stuff pop up on accident. I've left myself logged in, and other people let themselves logged in. They thought they were me. You know what I mean?
Sure.
So that it's so much easier to have it happen online on accident.
Yeah.
I doubt there'd be some change.
Good point. That said, the dissent highlights that the majority's analysis was objective, not subjective, which is supposed to be, right? Certainly, an argument could be made that she was foolish to expect privacy, says Judge Padovano's dissent. But the expectation of a 16-year-old cannot be measured by the collective wisdom of appellate judges who have no emotional connection to the event. Two stupid kids in love doing a stupid thing is what Judge Padovano's dissent is trying to argue. And there's some notes and questions to consider. My favorite is note 4. Get your tinfoil hats on, everyone. There I quote an article from a website called The Verve. Is that even journalism? I don't know. But The Verve talks about some of these Edward Snowden accusations. The particular one there that I mentioned is that the NSA was intercepting certain shipments of laptops that were bought online and adding a back door so that they could access those laptops. Is it true? Is it not true? Edward Snowden and the release on WikiLeaks made some bold accusations, some of which I guess weren't disputed, perhaps they were all disputed, about a lack of privacy that perhaps any of us might be suffering if we dare to use electronics in the modern era. So my question there is, if I want true privacy, need I go off the grid? Do I have to get rid of the iPhone, get rid of the Chromebook, get rid of the MacBook, the Echo Dot, the Echo Show, the Fire TV stick, the Xbox One? Can you still say Xbox and tell it to turn on? I don't have an Xbox. Alexa, turn on the TV, and she puts my TV on. Do I have to unplug everything? Do I have to get off the grid if I want true privacy? That's what I was asking there. And the reason I ask it is if we take the majority opinion quite literally, especially in its very awkward description of what modern technology looks like with them internets and the computers that talk to the servers, it almost implies that anyone involved with technology is limiting their legal right to privacy. Certainly they're limiting their practical right to privacy. But should the law say that from a legal standpoint, they've limited the right to privacy? And, you know, as we travel, the cell phone pings the cell phone towers. It's not uncommon for law enforcement to track a suspect after the fact by looking at those cell phone tower pings. I was just trying to do a previous day's invoicing, putting in my time for an hourly client, and I knew that I had traveled and I knew I'd encountered some traffic. I didn't want to overbill the client, but I didn't want to underbill them either. So I went to my Google Maps because I hadn't turned off the feature. It tracks me as I travel. And it told me exactly how long I took to get from where I started to the Olive Garden, where I had a nice lunch, when I left the Olive Garden and arrived at my destination, and how much time that was. I was able to bill the client quite accurately. So maybe there's advantages to these things. Maybe there's disadvantages too. Should there be a legal disadvantage? Is the question that we must answer as the future goes on. So those notes make those kinds of points. Right to privacy and right to refuse medical treatment. They took my clock down from back on the wall there. So forgive me for stopping to look at the time. Yeah, I figured as much. We're a little past due on our 10-minute break. So with your permission, can we make it a 7-minute break? That'll get us back here at 7 o'clock. Because I want to finish up our discussion of privacy today. I want to cover homestead. For some reason, everybody's always interested in homestead. True confession. Find it to be one of the dullest topics on the agenda. But I once tried to not cover homestead, and everyone wanted to hear what I had to say about homestead. So, homestead it is. We'll cover homestead, maybe even a little bit more when we get back in time permit. So let's take a 7-minute break. Sound good?
Now
All
it's
right.
6 minutes.
Oh, I talked through the first minute. Sorry about that.
It's okay. Go back in. There, you have to do what I'm.
Yeah. I didn't think
Yeah.
Yeah, I haven't set that up yet, but yeah, I just have like a different profile.
He's deleting. You didn't invite me? Who are you with? Megan's having issues.
I know, I'm trying to leave your lunch, just gotta catch your breath.
Oh my God, that was fun.
Yeah.
And then wait, wow, this wig.
Hey, dude, what's up, buddy? How you doing?
Good.
Yeah, did you get an email from Russell for class tomorrow, aviation law?
You have it, but I didn't.
Are we just meeting that class? 'Cause I thought you should go to
No,
the hangar.
No, that's I think it's after Thanksgiving. It's the last class.
So we're not reading anything tomorrow. We're just showing up.
Yeah. And you know what's crazy? Some girl brought this to my attention. We're getting our oral argument thing tomorrow. You know?
Yeah.
But he said we're gonna do it the next week.
Thanksgiving, yeah. So
And then the next week we're going to the hangar.
that's what I'm saying. Because
So
I
I'm
thought
like-
it was this week we're going to the
They'll have
hangar.
a field trip?
Yeah, it's gonna be cool.
He specifically
Yeah,
said,
it's for aviation. I'm taking us to a hangar to look at.
yeah.
I don't know.
to the corporate airport?
He didn't.
Yeah,
We're waiting.
exactly.
I'm trying to find out.
Probably exactly.
Well, JetBlue was.
He was JetBlue, and I'm like, that's pretty tough to do.
So I thought, yeah, he hasn't added me on emails before, so I thought everybody
No,
had an email again.
I remember him saying, no, you didn't. But I'll text the other girl I know. Just make
Yeah.
sure. But no, we're getting our.
So no, it's okay, but we don't have to do oral. All right, I'll show up then.
Yeah, just show up like normal, dude.
Change. Listen,
Have your,
like
your
this.
Reese's and your M&Ms.
I already got them. You want some?
No, no.
Sir, I just got a, speaking of electronic privacy, my girlfriend just informed me that someone hacked into my bank account and took all of my money and.
Are you
No joke,
I'm not kidding. I don't have an attorney next week because she has the other half.
Does this
Can I
grind
go
your gears?
try to deal with this?
I'm so sorry that happened.
Private bar.
So sorry.
Because they don't see shit.
Like 2 weeks after someone broke into her.
Maybe you can do one of those so then you can do
We'll charge the
Wow.
clients, they sign social proof that the current law doesn't recognize. And then they figure because it's going to get reported, that no one's going to report to the bar. And that's not stuff. Or report them.
Give me a list and check twice.
We've actually figured out, we've actually seen that does people listen to bar complaints like that.
Go. Wait.
I just thought of this one now. Talked about.
Yeah. I don't.
Yeah. That's what yeah.
Really? Like, I had a friend who got yeah, my dad was like that when there's things that people get in trouble for, he's like, don't say anything. Yeah. But that's like the criminal. He's like, don't say anything. Don't tell anyone anything.
Yeah.
Don't do anything.
Yeah. And I don't know what happened.
Yeah. I'm always under the impression that everything was easy all the time. And also, like, when people are like, oh, like, everyone already knows what they want to know about you. You don't try to be secret. They already know. They already know where you are all the time. They already know the access to all of your bank accounts. They have all that already. They know all of it. I don't understand.
I just did right now. We'll put it right here so he sees it.
Did everyone get it?
So,
Okay.
I'm told, man. I bet you pay more to get in this flat.
Yeah, I know. A little bit more.
Yes, you can.
Wait, what did he just say?
no, I didn't get it. I didn't get any.
We're between the two. We're like, no, I swear.
Oh, I should have looked there first. Yeah. All right.
Okay. I was two different topics.
Wait. Well, I mean, yeah. Yeah, I know. That's what I was waiting.
Just in case, I always take a picture of it. Is that the right to privacy?
I don't care. We're friends. We're closer than you are with her.
This whole third party mess.
Oh my God, then you gotta tell me right now.
So I have just a few words on the right to refuse medical treatment, because that gives me the background that we all need to ask the question, does Florida's right to privacy and its right to refuse medical treatment result in a right to assisted suicide? So I cover this material to get us into our discussion of euthanasia. So right to privacy and the right to refuse medical treatment, I gave as an example, Burton versus State. And here you see that the trial court stated the rule that as between parent and child, the ultimate welfare of the child is the controlling factor. And it notes in this case that the Florida Supreme Court has specifically recognized that a competent person has the constitutional right to choose or refuse medical treatment. And that right extends to all relevant decisions concerning one's health. And that quote is from a 1990 Florida Supreme Court case called In Re Guardianship of Browning. Guardianship of Browning. So a patient's fundamental constitutional right to refuse medical intervention can only be overcome if the state has a compelling state interest great enough to override this constitutional right. The opinion also notes the state's interest in the potentiality of life. Is it life or is it not life? The potentiality of life of an unborn, then they use the F word, I don't use the F word, becomes compelling at the point in time in which I don't use the F word, so I'll replace it with baby, with your permission. At the point in time when the baby becomes viable, defined as the time at which I omit the F word, the baby becomes capable of meaningful life outside the womb, albeit with artificial aid. And then it quotes a case that shall live in infamy, one named Roe versus Wade. It also, in addition to that Supreme Court of the United States case, cites to a case from the Florida Supreme Court, which may also live in infamy, called In Re TW. It's TW 551 Southern 2nd 1186. It notes that the Florida legislature has defined viability. And that definition we find in Chapter 390. It quotes it as that stage of development when the life of the unborn child may, with a reasonable degree of medical probability, be continued indefinitely outside the womb. So the case concludes the test to overcome a woman's right to refuse medical intervention in her pregnancy is whether the state's compelling state interest is sufficient to override the pregnant woman's constitutional right to the control of her person, including her right to refuse medical treatment. That's what we have here. The test to overcome a Floridian's right to refuse medical treatment is whether the state's compelling state interest is sufficient to override the Florida constitutional right to the control of privacy of her person. If so, then the state must show that the method for pursuing that compelling state interest is narrowly tailored in the least intrusive manner possible to safeguard the rights of the individual. You've heard all this in Common Law 1 when you studied federal constitutional law. So this is not news to you. What might be news to you, we talk about in this case of Pemberton versus Tallahassee Memorial Regional Medical Center. And I didn't give you the case in the material. Instead, I gave you a law review article, one that came from the William and Mary Journal of Women and the Law, written by Bonner and Sheriff, called The Child Needs a Champion, Guardian Ad Litem Representation for Prenatal Children. Instead of the F word, they used the phrase prenatal children. Well said. So there they talk about this case of Pemberton versus Tallahassee Memorial Regional Medical Center. And here, a pregnant woman was ultimately forced to have a cesarean section after multiple physicians concluded that vaginal birth posed a substantial and unacceptable risk of death to her child. And for those of us who haven't had a baby, and I think I'm fairly counted among them, although each time Bernadette has been pregnant, everyone always said, we're pregnant. Indeed, even Bernadette would say, we're pregnant. And, I guess I did my part. But I don't know that it was fair to say that we're pregnant. Because, when it comes to Bernadette and I, or any man or woman who find themselves pregnant, just in my humble opinion, I think it's the woman who's doing the majority of the work of the pregnancy. Indeed, as I observed it, this thing called labor was appropriately named. That really looked like labor to me. I remember Patrick James was our firstborn. He's 9 now. And, Bernadette loves her father-in-law. I love her father. I love him too. He's my father-in-law. We all love him. So Bernadette tends to think if that's how her dad did it, then that's the right way to do it. And there's beautiful stories of her father, who's an engineer, with these beautiful graphs charting how long between contractions, So, of course, Bernadette had the paper ready for me to chart how many minutes between contractions. But, all this was happening at like 2 or 3 a.m. And I don't know about you, but I sleep at those hours. So I pretty much slept through the contractions, except I kept getting woke up to ask if I had timed it. And, I go, oh, yeah, it seemed like about a minute or so. But I had been asleep for, I don't know how long, 2 minutes, 5 minutes, 10 minutes. So, people tend to say we're pregnant, but I think we should have more respect than that. I think a woman who's pregnant truly goes through labor. And, one of the things Bernadette wanted to do, one of the things many women who are pregnant want to do, is to have a birth plan, to plan out exactly how this is going to happen. And for Bernadette, it was very important to have a natural birth, but ultimately, like in Pemberton versus Tallahassee Memorial, there was a cesarean. Now, because of insurance, most doctors won't, most OBGYNs, obstetrician, gynecologist, doctors won't get involved in a vaginal birth after cesarean for a second or third or fourth child. As a matter of fact, they even have a name for that. It's called a VBAC, vaginal birth after cesarean. Because the insurance companies, many of them, simply won't write a policy for an OBGYN who will do a VBAC. Others will give the OBGYN insurance, but exclude any coverage for a VBAC. So many pregnant women who are engaged in a birth plan are highly interested as to whether or not there's going to be a cesarean. Because for many pregnant women in many areas of our state and in our nation, once a cesarean, always a cesarean. And that may not be the woman's choice. So what we have in cases like in Ray guardianship of Browning that I referred to earlier, and as we see it implemented in cases like Pemberton versus Tallahassee Memorial, we have a procedure set up in the state of Florida to determine whether or not we're going to listen to the pregnant mother who wants to go on with labor, and God bless her. If you haven't seen it, it truly is laborious. It truly is labor. Or whether the woman wants to have a cesarean. Like these facts, physicians can come to a different conclusion than the mother. Which do we follow? What do we do? Do we listen to the mother and her birth plan and what's right for her and for her child? Do we listen to the physicians who have an opposite choice? Under Florida law, we have a procedure set forward because of cases such as in Ray guardianship of Browning. And what the hospital can do is to contact the state attorney, who then contacts the court. And the judge will literally, this is what happened in Pemberton. It was Judge Padovano in Pemberton, because at that time he wasn't on the first DCA like he was when he wrote the dissent in AW. He was instead chief judge for Tallahassee for the First Circuit of the state of Florida. So Judge Padovano literally went to the hospital, went to the pregnant mother's bedside where she is in labor, and holds an evidentiary hearing and decides whether the doctors who want to do something other than the mother get to do what they want to do, or the mother who's in labor gets to do what she wants to do. Later case law clarifies that this doesn't violate due process. Indeed, later case law clarifies that the mother has no constitutional right to counsel. So imagine, if you will, if you can, I'm male, so I can't, that you're in labor. I've never been in labor, but it looks awfully distracting to me. I'm not saying that a woman can't put on an evidentiary hearing, spur of the moment, unexpectedly on a weekend or an evening. I'm not saying that a woman can't do that while in labor. I'm just saying that she's probably distracted at the time. Anyone want to disagree with that? Wouldn't the labor be a little distracting? You've got a birth plan and you're going to the hospital. Part of it probably wasn't to put on an evidentiary hearing, right? Imagine you hadn't even gone to law school. Florida law says that woman who's distracted because she's in labor, has never been to law school, has no right to an attorney. And the government can override her wishes. So that's how that works. If you want to use the word work. Yes?
In that case, was she at risk for death as well?
The allegations of that case are not well spelled out in your text because I gave it to you as summarized in the law review article. But my understanding was that Judge Padovano found that the risk to the child and the mother or both outweighed the benefit of the mother having the choice and sided with the physicians, multiple physicians. And that's why her choice was overruled. That's my understanding of the case. And indeed, that would be the legal standard to apply. But look at the conditions upon which it's applied. So, note 1 and note 2 ask you what you think of that. I guess it's pretty obvious from my description of it what I think of that. But again, I'm not here to indoctrinate, I'm here to educate. I guess the opposite argument would be, at least the doctors can't just ignore the mother and the child. At least they can't just say, sorry, we disagree. Here comes the scalpel. At least they have to get some impartial, and in this state, elected official, a judge, to come and make the decision. So I guess that would be the counter argument. In Ray TW holds that it's error to appoint guardian ad litem for the person who needed it the most in that particular case, the unborn child. The mother in labor is certainly distracted and might find it hard to speak, but the unborn child who's in labor would literally find it impossible to speak. It is error, says the Supreme Court of the state of Florida, to appoint a guardian ad litem for that individual. Moving on. Does Florida's right to privacy, we know they have one. Floridians have it. And Florida's right to refuse medical treatment, we know we have one. Floridians have it. Does that result in a right to assisted suicide? And that brings us to the case of Krishner versus McIver. By way of background, Florida statute section 782.08 has been on the books for many decades, read then at the time of Krishner versus McIver as it reads now, and reads as follows. Every person deliberately assisting another in the commission of self-murder shall be guilty of manslaughter, a felony of the second degree. Is it legal to assist a suicide in Florida? There's the answer. The answer is no. What is the penalty for assisting a suicide in Florida? There's the answer. It's a crime. It's a felony. Krishner versus McIver is a 1997 decision of Florida Supreme Court. Charles Hall and his physician, Cecil McIver, MD, wanted a declaratory judgment holding that this 782.08 violates the privacy clause of Florida's Constitution, violates due process, says Mr. Hall and Dr. McIver. They seek an injunction against the state attorney from prosecuting Dr. McIver when Dr. McIver does what Dr. McIver intends to do and deliberately assist Mr. Hall in committing suicide. After a 6-day bench trial court issues a final declaratory judgment and issues the injunction. The court concludes that this 782.08 cannot be constitutionally enforced and enjoins the state attorney from prosecuting Dr. McIver if Dr. McIver and Mr. Hall decide that Mr. Hall will commit suicide. The trial court makes that decision based on Florida's right to privacy and the federal equal protection clause. Mr. Hall's 35 years old at the time. He suffers from full-blown AIDS. The court finds Mr. Hall's mentally competent, finds that his health is deteriorating, that he's clearly suffering, and that he's terminally ill. Surely we've got to have sympathy for Mr. Hall and for any of us, any of our brothers and sisters who are suffering from a terminal illness, whose health is deteriorating, who are tempted to say, life isn't worth living anymore. Surely we've got to have sympathy for such individuals. But does that mean that this law is unconstitutional? And what we find is that the holding of Krishner versus McIver is no, it is not unconstitutional. How did the court reach this point? Well, first, it engaged in an analysis, which sounded like it was making the policy decision as to whether assisted suicide should be allowed in Florida. The beginning of the analysis sounds like the court is taking an activist role. Sounds like the court's going to write some legislation for us. Sounds like there might be some penumbras formed by emanations from the state constitution. It sounds like that in the beginning and the middle of the opinion. But ultimately, that is not how the opinion turns out. Ultimately, it's not an opinion about judges on Florida Supreme Court substituting their will for the will of the people of the state of Florida. Ultimately, it's an opinion where judges, instead of being activists, show deference, show that the proper place for making policy decisions under Florida's Constitution is not the Supreme Court of the state of Florida, but instead is the people, the citizens, the Floridians themselves, speaking through their duly elected officials, acting in a republic democracy to enact laws that reflect what the policy decisions of our state is. Kushner versus McIver holds that the proper policy decision-making body under Florida's Constitution is not the executive, is not the judicial, but is the legislature, is you and I, is the people of the state of Florida speaking through their elected officials, taking a vote, passing and amending laws. That's who gets to make the policy decisions. But they do discuss, in the opinion, matters of policy. They talk about how in 1984, Governor Mario Cuomo convened the New York State Task Force on Life of the Law. It had a mandate to develop public policy on a number of issues with respect to assisted suicide and euthanasia. The New York Task Force concluded that New York laws prohibiting assisted suicide and euthanasia should not be changed. The task force said assisted suicide and euthanasia would carry us into new terrain. American society has never sanctioned assisted suicide or mercy killing. The task force addressed this issue again in a supplement to the report and reaffirmed the position. They also mentioned the Advocacy Center for Persons with Disabilities. This was a Florida nonprofit corporation organized pursuant to an executive order of the governor of the state of Florida. It was charged with the responsibility of carrying out the federal mandated and funded protection and advocacy system for persons with disabilities in the state of Florida. They filed an amicus brief. In their brief, they argued to give someone, including a physician, the right to assist a person with a severe disability in killing himself or herself is discrimination based on a disability. They argued to give someone the right to assist a person with a severe disability in killing himself or herself, that's discrimination based on a disability. It lessens the value of a person's life based on health status, they argued. It subjects persons with severe physical and mental disabilities to undue pressure to which they may be vulnerable, their amicus brief argued. The court held, we cannot agree that there's no distinction between the right to refuse medical treatment and the right to commit physician-assisted suicide. The assistance sought here in Kushner versus McIver, says Florida Supreme Court, is not treatment. It's not treatment to end a life, says Florida Supreme Court. It's not medical care to take away life, says Florida Supreme Court. It is not a right to health or reproductive health if it results in death. We cannot agree, says the Florida Supreme Court, that there is no distinction between the right to refuse medical treatment and the right to commit physician-assisted suicide. The assistance sought here is not treatment in the traditional sense of that term. It is an affirmative act designed to cause death, says the Florida Supreme Court, no matter how well grounded the reasoning behind it. They then talk about the American Medical Association. They talk about the oath that a physician takes to do no harm. But ultimately, after discussing all these things and noting that the state has a compelling interest in maintaining the integrity of the medical physician and the medical profession. So they hold there is a compelling state interest in maintaining the integrity of the medical profession. After that, they state the following. Quote, we do not hold that a carefully crafted statute authorizing assisted suicide would be unconstitutional, nor do we discount the sincerity and strength of the respondents' convictions. However, we have concluded that this case should not be decided on the basis of this court's own assessment of the weight of the competing moral arguments. By broadly construing the Privacy Amendment to include the right to assisted suicide, we would run the risk of arrogating to ourselves those powers to make social policy that as a constitutional matter belong only to the legislature. We reverse the judgment of the trial court and uphold the constitutionality of Florida Statute Section 782.08. So the court did not say, here in Florida, the Constitution means whatever the Supreme Court of the state of Florida would like it to mean. The court did not say, here in Florida, the policy decisions, the weighing of morality is the role of the Supreme Court and not the people speaking through their legislature. Instead, the Florida Supreme Court said the opposite of both those things and said that the policy decisions are to be made by the legislature. So what do you think? Whether on a state or a local level, should we trust you and I to make policy decisions? After all, look to the left of you, look to the right of you, look behind you, look in front of you. Maybe one of those persons just isn't as smart as you are, right? Why should we trust each other to make these decisions? Why not elect someone who then instead appoints someone for life, who then instead makes our decisions for us? Because if we do that, right, doesn't matter if the person to the right or left, behind us and in front of us is smarter or wiser or not as smart or not as wise as us, because we're not relying on each other anyway. We had some elected officials appoint some unelected officials who then will decide moral issues of the day. Isn't that the better system? Who would take the opposite argument? You can tell from my sarcasm I don't like that system. Right? Why would it be better, hypothetically speaking, for the people themselves to decide what the morality of their society should be? Nobody wants to argue that. Yes.
Because local problems and local solutions.
Loving it. Thank you. Thank you. Thank you. Hats off. Hats off, sir. Yeah. Subsidiarity at its finest. Stated beautifully. Thank you. Thank you. Sometimes local problems need local solutions. Thank you. All right. And that's a fun topic. But what could be more fun than homestead? Life, death, euthanasia, abortion, morality. No, let's talk some homestead, shall we? Yes. Everyone wants to study homestead. I'm not sure why everyone wants to study homestead. That's what I usually hear. It's on the bar. It's on the bar. Yeah, because we all know what's going to be on the bar, right? No. Rumors persist that it will be on the bar. These people, I guess they're mystics. They have a crystal ball. They can see the bar that doesn't exist and tell you that it's on there. In Homestead's defense, there's rarely anything in state constitutional law that is unique. Have you noticed that? Have you seen a lot of greater rights or unique rights as we've gone through the semester? There's not a lot of those, are there? But maybe Homestead's one of them. So I'll give that. But people tend to think that Homestead is complex. And personally, I think Homestead is very simple. And it may be just because some of us come from somewhere other than Florida that may be why we think it's complex. But it's quite simple really. Homestead's a city, the Miami-Dade, Florida. It's right there. It's about 14 and a half square miles, about 35 miles southwest of Miami, about 25 miles northwest of Key Largo. And they've got a racetrack there with an annual NASCAR race. There you go. It wasn't hard, right? Any questions about Homestead before we move on? You know I'm kidding, right? There really is a homestead, but that's not our topic. Our topic is the constitutional right to homestead appearing in the text of Florida's Constitution. Indeed, we can find it in Article 10, Section 4. If you look here in Part A, there shall be exempt from forced sale under process of any court. No judgment, decree, or execution shall be leaned thereon, except for the payment of taxes and assessments thereon. Obligations contracted for the purchase, improvement, or repairs thereon, or obligations contracted for the house for the following property owned by a natural person. Does that mean unnatural people can't have a homestead? Well, it means to a certain extent that you've got to be flesh and blood, but has also been interpreted to mean that you may own your property in a trust. Many prefer an estate plan that involves a revocable living trust. Some folks choose an irrevocable living trust, far less popular than the revocable living trust. So placing your home, if done properly, in trust where you are both settlor and trustor, and the trust remains revocable and is titled correctly, will not, N-O-T, not, defeat your homestead entitlement. But other than that, it's got to be a natural person. So maybe you own the beach house as an LLC or the rental properties in another LLC, not going to get homestead on those. A homestead, it's got to be a certain size. So if it's located outside a municipality, you get 160 acres. Why 160? What's the logic behind 160? There is none. Just got to memorize that. Not for my exam, I won't ask you. But for these folks who swear it's on the bar, I guess you got to, these individuals say, oh, it's on the bar. I've been told it's on the bar. I guess you'd memorize the 160. Well, if it's located within a municipality, it's not unincorporated, then you get 1/2 acre. And either time, it's got to be contiguous land. So I don't know, maybe you're rolling in the dough and you want to buy a lot down the street to put your tennis court on. Cool, daddy-o. But unless it's contiguous, it's not going to be homestead. And if you go over the limits on size, it's not going to be homestead. Exemption is limited to the residence of the owner or the owner's family. It's been tried without success for a married couple to say, hey, this is the husband's homestead and that's the wife's homestead, to try to get 2 homesteads. And unless there's a genuine legal divorce under the law, then the law is not going to recognize 2 homesteads. In addition to that exemption for the home, you also get $1,000 of personal property. Ooh, a lot of money, huh? Might have been when they put it in the Constitution. Also, these exemptions shall inure to the surviving spouse or heirs, the owner. So, under N. Ray Cook, when is a Florida home a homestead? Florida Realty is a homestead. Okay, first of all, note the word realty. Maybe you're living in your car. Maybe you're living in a van down by the river. Thank you. Thank you for catching that reference. Yes, that was Chris Farley, right? May he rest in peace. Yeah. If he were here today, he'd probably fall on top of his podium and crush it, right? The physical comedy was great. Yes. So you may be living in something other than realty, not going to get homestead on that. Also, it's got to be owned by a natural person. We already discussed that. It jumped ahead a little bit. Remember what I talked about there? LLC, revocable living trust, ding, 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 ding. Right? Who intends it to be his or her permanent residence? Interesting. That was in the news lately. Did you see that the President of the United States filed a document stating that Florida was the president and the president's family's legal residence? So that's one way to do it, but it's not the only way. Indeed, all the law requires is that you had a subjective belief that that was your home. Now, if you've been in Florida long enough, you see why some people joke and call it heaven's waiting room. A lot of people move here to die, right? And ultimately, they succeed in that goal. But for many, before achieving the ultimate success, they may find themselves in a nursing home, convalescent center, right? The question isn't whether they moved out. The question is, in their subjective belief, did they believe that they'd go home someday? So, elderly individual owns realty in Florida, considers that realty their homestead, has no other home, but for health reasons, goes to a nursing home. If sufficient affidavit testimony will establish that grandma or grandpa, wherever that elderly person was, honestly believed they were going back to the house someday, then that house is going to remain a homestead. For how long? For how long can they be absent under the law? A day, a week, a month, a year, 10 years? For as long as they maintained ownership with that reasonable belief that they would return, and with them considering that real estate to be their homestead despite their current living circumstances. So an elderly person spends a decade, 2 decades in the nursing home, never sells the house, with sufficient affidavit testimony of their own subjective belief that someday they would go home. Sounds implausible, but the question is not an objective standard, a subjective standard. If they believe they'd go home, then that remains their homestead. So Florida Realty is a homestead when it's owned by a natural person who intends it to be his or her permanent residence and who is a legal owner. Chose my words wisely, a legal owner. If you look at my chapter, I've got Joe Procopo's article excerpted so many times in there that I really should have given him co-author status of my chapter, right? But thank you, Joe, if you're listening. He did give me permission. And so did the Florida Bar. They gave me permission to reprint his article because they printed it to begin with. But read Joe's article if you want to see an exhaustive analysis of what level of legal ownership. You remember property law, right? You remember that analogy that it's a bundle of sticks, and which sticks do you own? Check out how few sticks you can own and still have a homestead. It's very, personally, I find it boring, but it could be very interesting to you. Could be very interesting. And who is a legal owner of the real property, and that real property meets the size and contiguity requirements of Florida's Constitution. What if the homestead is jointly owned? Florida statutes provide that a homestead jointly owned via tenancy by the entireties. What's that? Spouses, right? It's tenancy by the entireties would be a joint tenancy with rights of survivorship. What's that? That means we both own it now, or maybe the 3 of us own it now, maybe the 10 of us own it now, and as each one of us dies, that undivided ownership now vests fully with those who survive, right? So, Florida statutes provide that a homestead jointly owned via tenancy by the or via joint tenancy right to survivor becomes solely owned by the surviving owner upon the co-owner's death. It does so free and clear of the deceased debts of financial obligations, except taxes and liens for purchase or improvements to the property. Ooh, interesting, right? I need a new roof. I hire a roofer. They hand me a bill for $10,000. I say, thank you for the bill, but this is my homestead. I'm not going to pay it. What happens when you go to court? You become homeless because they can take your home for an improvement upon the home. Homestead won't beat that. What if You like this house, but it's $200,000, and you check your bank balance, and in cash, you have slightly less than $200,000. So you take out a mortgage, even though you don't have the $200,000, the bank does. So the bank pays the $200,000, but you get the keys. Next month, the bank says, what? We'd like our mortgage payment. And you say, this is my homestead. I'm not paying you. And they foreclose. What do you become? Homeless. Yes, you become homeless because the homestead is not going to survive a mortgage. It's not going to survive a lien. It's not going to survive an encumbrance. Say you're mowing the yard. This happens sometimes. Somebody comes up and they're just looking for work, right? You weren't planning on doing this or that, but it'd be nice to have this or that done. So you throw him or her a bone and they do the work. Now there's a dispute about what's paid because swore they said $100. Now they're saying, no, you told me $400. They put a lien for $300 on your house. Can they collect that? It's your homestead. Yes, they can. This isn't an example like a mortgage where you voluntarily put the lien, or like the roofers where you hired them and signed a contract for the lien, but it's a mechanic's lien. It is work done upon the homestead. That's not going to survive the assertion of a homestead exemption. So the survivor is going to get the house free and clear of debts and financial obligations, except those liens for purchases or improvements. Besides death, what's another thing? The cliche says there's two things you can't avoid in life. What's the other thing? Taxes. Yeah. Say the IRS, you owe some back taxes. Say it's got nothing to do with your house. Say in addition to owning a house, you also run a law firm. And at your law firm that you own, you've got an associate and a paralegal. And you, fell behind. God forbid, I've never done it. Praise God, hopefully never will. You fall behind and you don't have payroll. Thank you, Jesus. I've always had payroll. And now you owe some past taxes. But IRS, those taxes had nothing to do with the house. But the IRS says, as the business owner, at least for part of those taxes, the withholdings, you're personally liable. You personally withheld the taxes. Now hand it over to us, the IRS. I don't have it. That's okay. Now you're something else. What's that? Homeless. Because the IRS will take your house despite the homestead. Defense number one. That's not fair. How does that usually work out in a homestead situation? Exceptions put aside, that's not fair usually doesn't work out. Okay. If you assert the homestead and you skunk a creditor, in a typical fact pattern, there are exceptions. When the creditor's defense is, that's not fair, the creditor loses. Homestead is not a matter of equity. It's not an equitable relief. It's not an equitable sword or shield. The equities really don't matter when it comes to homestead. What is meant by the Florida Constitution saying that homestead cannot be devised? What's meant by that? It means three things. First of all, the deceased estate plan, whether that's a will, a revocable living trust, etc., does not void or avoid homestead protection when there is either a surviving child or spouse of the deceased. Because in such an instance, the estate plan, whether it's a will or a revocable living trust, does not control the devise, the homestead, when there's such survivors. It's a beautifully written will, leaving it all to somebody else instead of the spouse and the surviving children. Well, nice work in drafting, but not effective, because that estate plan does not control, does not void or avoid the homestead protection when there's either surviving child or spouse of the deceased. The other thing it means, there's a lot here and a little bit of language. The surviving spouse is going to inherit despite any estate plan, whether it's a will or a trust. The spouse is going to inherit either A or B, the spouse survives the deceased. Choice A is the spouse is going to inherit either a life estate or an undivided 1/2 interest. It's going to be a life estate unless the deceased has children that survive the deceased. Then it's an undivided 1/2 interest. And they, per stirpes, hold the vested remainder. That's choice A. Choice B, if the deceased's children did not survive the deceased, then the spouse inherits the homestead in fee simple. What's the one and only exception to that? If the spouse waived that right. So this is an instance, a rather limited instance of waiver. What if you want to take out a personal loan or a credit card at a good interest rate? Do you get to negotiate the terms of the credit card? How many of you have a credit card? How many of you got to sit down with Visa or MasterCard or whoever wrote the card and discuss paragraph 3 and what should be in paragraph 4 and whether you like the language of paragraph 7? Doesn't happen, right? So why not, if your Visa and MasterCard, just stick in there, cardholder hereby waives homestead? Not enforceable. Can't waive homestead. What if credit card company says, all right, we're going to give you a $900 credit limit at 18%, or I'll give you a $4,000 limit at 9% and a $500 signing bonus if you waive homestead. And the choice is yours. You're already approved. Just tell us which one you pick. Now, has the credit card company avoided homestead? There's consideration. There's options. No. No. So when we see here this one limited example where homestead can be waived, don't blow that up and misinterpret that to mean that this is a waivable right. Generally speaking, it's not. There's an example of a waiver, but generally speaking, homestead is not waivable. Third thing that is banked by the Florida's Constitution saying that the homestead can't be devised is that despite the estate plan, whether it's a will or a trust, the surviving children of the deceased are going to inherit, if there's no surviving spouse, the homestead in fee simple. And how do they own it? Tenants in common. Tenants in common. All right, let's put that good knowledge to use. You've just met with the grieving family. Mom died several years ago, left everything to dad. They grieved then, but they're grieving today because dad just passed away. He's left a house worth $200,000. He hadn't finished paying the mortgage yet. Today's payoff amount is $50,000. He has a credit card where he owes $5,000. And he has a bank account where he holds $500. Choice A, we sell the house to pay off the credit card and to pay off the mortgage. Is that right? Not if it was his homestead. How do we know if it was dad's homestead? Did he live there? If so, is there anybody willing to swear? Remember, he's dead. An affidavit testimony that he considered it his homestead? Easy to do if he didn't live anywhere else, right? Can it be done if he was off in the nursing home when he passed away? Sure. What if he's kicking it in the Caribbean when he passed away? Sure. Absence won't defeat homestead. What if he's moved to France? Got an apartment over there. Well, here's the affidavit. Did dad subjectively believe that was temporary and considered Florida to be his homestead? Any of those examples would mean that we don't sell the house to pay off the $5,000 credit card. Now there's $500 in the bank account. That's going to the credit card company. But not right away. Remember, you're the lawyer in this hypothetical scenario. First, you get your cut. because you're an administrative expense of the estate. You come before the credit card company. So here's the credit card company. They're owed $5,000. They get a maximum of $500. They probably get nothing after your bill. Can they foreclose on the house? Yes or no? Not if it's a homestead. How about the other creditor? Dad died before he paid off the mortgage, $50,000. Can they foreclose on the house? Yes. Yes. That was among the exceptions. Remember, we didn't have homestead, right? Taxes, liens for purchase or improvements to the property. The mortgage was to buy the property. So you got to pay off the mortgage. So what if the heirs all kick in to pay off the mortgage? That's $50,000. What then becomes of the house? It's theirs, free and clear. Then Visa comes knocking. Your father owed us $5,000. Pay up. What do? You file suit under the Fair Debt Collection Practices Act, win, and collect attorney fees because they didn't have a claim. That was homestead. Homestead meant it was theirs free and clear of Visa, not free and clear of the taxes, not free and clear of the mortgage for purchase or improvements, but free and clear of all other debts. What about equity? So Visa files an affirmative defense and a counterclaim to your FDUPA action, unjust enrichment. What do you file in response? Motion for sanctions for a frivolous claim by Visa, because there is no such defense to homestead. Is homestead equitable? No. It's wickedly unfair to the creditors. That's how we've set it up. But watch out. What if you're the creditor? I bring your attention now to the case I got in the book here. I better turn to Quiroga versus Citizens Property Insurance. If yours is printed in the same binding as mine, I'm on page 375. What happened in Quiroga versus Citizens Property Insurance? There was a hurricane. There was damage to the house. The insurance company didn't pay. So the homeowner hired you, the Florida attorney, and you were brilliant. You got the entire policy limits tendered by the insurance company, even though they were denying the claim and refusing to pay a dime. And you did so because you and your client signed the Florida Bar contingency contract, dotted the I's, crossed the T's, used the form that was online, obeyed all the rules regulating the Florida Bar. Perfectly ethical contract. Client signed it, wasn't under duress, knew what they were signing. You put the money in the trust account and you send them 66%. You're keeping 33%, explains the letter, because that's what the contract says. Client calls you up and says, I'm sorry, I need one more check for your 33%. I'm keeping it all. We have a contract, says the lawyer. Send me my money, says the client. You do the right and ethical thing. You put your money, which was your money until the lien was asserted, back in the trust account, and you go to court, you as the lawyer file, and you say, Judge, put the money back, but it's mine. What's the judge say? No, it ain't. Give it to your client. It's homestead. Homestead protects from liens of creditors not only the value of the home, but the improvements thereupon. The reason the insurance company paid was because of damage to the home. Client gets 100%. You get nothing. That's not fair. That's a breach of contract. That's inequitable. You state those three defenses. Thank you for stating those, says the judge. Those three defenses are denied. Give your client the money. Was that the right outcome? Yes, it was. And as I close my lecture, I'll leave you with this unresolved question. Why do people take hurricane claims out of contingency? Until next 2 weeks. Next week is Thanksgiving. Until the next 2 weeks, may God bless each and every one of you. We'll wrap it all up next week.
Have a good Thanksgiving.
Thank you. Yeah, you too.
Professor, do you have the sign-in sheet?
Oh, yeah, you didn't sign it? Oh, gosh, you gotta sign it. Let's get credit, right? Yeah, all right. Everybody sign in for attendance? Everybody sign? Okay.
I thought you were still there.
I saw you over there.